Hello friend, how are you? I'm Advocate Gaurav Kumar Gupta. I am Chartered Accountant and MBA Finance and PhD holder. My project है Derivative Market Future Trend Analysis. आज हम टॉपिक डिस्कस कर रहे हैं सीपीसी सिविल प्रोसीजर कोड 1908 के बारे में जिक्र कर रहे हैं। सीपीसी में सेक्शन 151 को हम आज जिक्र कर रहे हैं। 151 हमें बताता है सेविंग ऑफ इनहेरेंट पावर ऑफ कोर्ट। सेविंग ऑफ इनहेरेंट पावर ऑफ कोर्ट 151 सीपीसी की धारा बताती है सेविंग ऑफ इनहेरेंट पावर ऑफ कोर्ट। नथिंग इन दिस कोड शैल बी डीम टू लिमिट otherwise affect the inherent power of the court to make such order as may be necessary for the end of justice to prevent abuse of the process of the court. Prevent abuse and of the process of the court. First of all, appeal and not file from the order. Appeal not filed from the order. Only application filed under section 151. 151. Court under inherent power would definitely entertain such an application provided there was sufficient cause of exercise of such discretion. In the instant case, it had been submitted that the only ground that had been made out in para 60 and 70 of the petition, where it had been barely stated that the not filing of the affidavit of document was not intentional but accidental due to inadvertence inadvertence on the part of the petitioner advocate on record in filing the same with the leave of the court. Appeal power of court. MPL power of court to pass an order of restitution under a division bench of Calcutta High Court held that even assuming that the provisions of section 144 the code of civil procedure do not apply in turn the court undoubtedly had ample power to pass the order for restitutions under section 151 of the code. 151 of the code, where application was filed, where application when application was filed, the quoting a wrong provisions of law, it was held that the mere fact that the combined applications is filed they mention both order and rule as well as section that does not make it invalid. SK Naglar Coal Depot versus Syndicate Bank 1995 ALT 8044, where the order for interim injunction was violated by defendant, the order of mandatory injunction under section 151 restorations of possession is just and proper. Application for interim injunction. Interim injunctions के लिए application. Plaintiff had initiated criminal prosecution. Plaintiff had initiated criminal prosecution against the defendant, which had been pending since 1975. The protections by a restraint order was sought by the plaintiff after a lapse of almost 6 years from the intention of those proceedings when the present suits was filed in March 1981. If the plaintiff really intended protections of his property in the trademarks, one would have expected such proceeding when the prosecution was launched soon thereafter. If these proceedings could wait for a period of almost 6 years, there would appear to be no urgency for the kind of order that is sought by the plaintiff. Validity of application. Validity Validity of application. Validity application for grant of temporary injunction filed under Section 151 CPC, Civil Procedure Code. The applicant case that the goods would be damaged by passage of time would be covered under Order 39 Rule 1A CPC. The mere fact that the application of the defendant 3 and 4 was filed under Section 151 CPC would not come in the way of the court guaranteeing of injunction under Order 39 Rule 1A. Central Warehousing Corporation versus Prabhu Narayan Singh 2003-5 AIC 794 at 796 all. Application under for setting aside decree not maintainable. For setting aside decree not maintainable. Application under section 151 was not maintainable as there is a specific provision for appeal. If really the opposite party were aggrieved by the compromise decree on the ground that is was defective as the parties did not sign the term of compromise were vague, uncertain, then the proper remedy for the opposite party was to prefer an appeal. The application under Section 151 of the Code for setting aside the decree was not maintainable. It cannot be said that any mistake was committed by the court. The said mistake was corrected by setting aside the decree if really the petitioner felt aggrieved by the compromise decree. The proper remedy for that was to prefer an appeal. Acquisition of and the provides house seats whether trial court has got power to award interest under any other act where compensations was awarded on acquisitions of land to provide house seats. Amount of compensation was enhanced in appeal. Interest was allowed at the rate of 12% till date of actual payment, held that interest could be awarded only in accordance with the provision the provisions contained in section 233 1 clause A 28 and 30 of the Land Acquisitions Act 1894. Therefore, matter was remanded to the trial court to examine where it had got power to award interest under any other act. A special solicitor Gamia versus Smith Galisami 2003 ad interim injunction. When can be granted in order to entitle ad interim injunction, pray for it is incumbent upon the plaintiff to show that he has prima facie case under further also to show that balance of convenience lies in the grant of an interim injunction. Pray for otherwise injury irreparable injury would occasion to him. Amendment of decree. Though the appeal is not maintainable on the merit, also the questions of section 152 of the code cannot and does not at all arise so far as section 151 is concerned. It is to be remembered that in this particular case, it is not mere and a simple mistake of the nature like mistake in the descriptions of land in plant, as in the case of Lakshmi Nath Sharma versus Gankanti Kalatni, ILR 2 Calcutta 407. This is a case where even according to the plaintiff appellant, the whole schedules was given wrong. That is not a mere mistake, mutual mistake. The mistake arises out of something before the plaint was filed.
There is no questions of wrong descriptions in the plaint so far as the property's mortgage are concerned. Descriptions of the property given in the plaint in accordance with 1975 agreement itself, it is according to the schedule of 1995 agreement. Accordingly, the case cited has no application. High Court cannot exercise its power of amending a decree, the result of which would be certain new agreement between the parties by changing the schedules as such, which is not the function of duty of land, not within the power of the court. Application for maintenance, pending suit for partition. Applicability of an application under Section 151 CPC for grant of litigations, maintenance during the pendency of litigation is admissible under the law. It can't be said that since there is no provision in the Code of Civil Procedure for grant interim relief in a matter like the one in the present case, there is a prohibitions to grant the same in appropriate case. The power of under Section 151 CPC should be exercised and relief be granted. Breach of interim injunction in the application for poli- police protection, it was alleged the petitioner were interfering with position in spite of the order of interim injunction. The respondent who has obtained interim injunctions could invoke provisions of Order 39 Rule 2A instead of resorting the police protection. It was, however, always opened for the parties to seek police protections to see that interim injunction order was properly implemented. It could not be said the court was not competent to provide police protection in exercise of inherent power. Death of arbitrator before filing award and not authorize the file award. Effect of, although protect the arbitration proceeding may have been held in the particular case in accordance with an agreement between the parties. All the award may have been made and there may not be any dispute about the authenticity of the award of the proceeding, but in all these cases, if the arbitration dies without filing in authorizing any other persons to file in file it on his behalf, all the proceeding before the arbitrator, which is the parties, have chosen themselves must become futile. This can't be the intention and object of the Arbitration Act. Take the fact of the present case, the arbitrator had hardly any opportunity to file the award. Within about 20 days of the making of the award of arbitrator die, the filing the filing of the award of Ministerial Act, no dispute has been raised about the authenticity about the proceeding. Inherent power of the court under Section 155 CPC can also brought at the end eventually. The court should not exercise inherent power if the order can be challenged under any other provision. अगले वीडियो में हम द कोर्ट शुड नॉट एक्सरसाइज इनहेरेंट पावर ऑर्डर कैन बी चैलेंज अंडर अदर प्रोविजंस के बारे में डिस्कस करेंगे. कोर्ट का इनहेरेंट पावर क्या है इसके बारे में डिस्कस करें. डिसमिसल ऑफ एप्लीकेशन, रेक्टिफिकेशन, मिस्टेक, एडिंग वर्ड्स, पावर ऑफ अटर्नी. पावर ऑफ अटर्नी का क्या पोजीशन है, किस अनुसार से रेक्टिफिकेशन किया जाता है, उसका सुधार कैसे किया जाता है, मिस्टेक्स को डिसमिसल मिस्टेक्स को कैसे किया जाता है. अगले वीडियो में, आज का वीडियो यहीं पे वाइप आउट कर रहे हैं.